U.S. board members will be able to vote and participate in all aspects of our meeting today, so that's exciting. Starting first with the approval of the minutes from the previous meeting. This is a much quicker turnaround than usual, as our previous meeting was just last week. Has everyone had an opportunity to look over the minutes? Anyone have any additions or edits? Nope. I would entertain a motion to accept it. Thank you. And a second, please. All in favor of accepting the minutes, please say aye or raise your hands. All right, thank you. And with that, I will turn it over to the Inspector General.
Well, I will start off by saying good afternoon. I know that they have me on here for the updates, but since I gave everyone my updates last week, I'm good. But if there's any questions or anything, just please let me know.
I don't think so. Thank you.
Okay, thank you.
All right, at our last meeting, we took a look at a Civilian Police Review Board discipline policy discussion. I'm now going to turn it over to Mr. Tobias to give us an update on the outstanding questions we had about the board's authority to enact discipline.
I told Ms. Ross that I was practicing at home in the mirror. The answer is no. It boils down to basically 4 points. Number one, the board members are not city employees. Number two, you're in a volunteer position. Number three, you're not part of any bargaining unit. And number four, the charter and the statute provide you with limited authority for removal only, not any provisions related to progressive discipline. So my advice would be for your discipline policy discussion that you limit it to the removal provisions. Chair Burns, I believe you had initially sent out a draft, which I redlined a little bit and sent back, and I think that just stuck to the removal provision and nothing involving discipline, even though technically removal could be considered discipline in a broader sense. But I would say no progressive discipline, please.
Does anyone have any questions for Mr. Tobias? So turning back to, if everyone remembers, we did have, or at least we were entertaining motions on the floor. We tabled them about the language in the policy. Given Mr. Tobias's instruction on the lack of discipline authority, the only edit I made, there were two, was one, adding in a provision that the board member against whom an allegation has been made is notified at the same time as the board chair that an allegation has occurred. And then second was to just remove the words "and discipline" or "discipline and include just removal." Does anyone have any other edits or thoughts pertaining to the policy with those changes? Hearing none, I would entertain a motion to accept the new policy as written. Thank you. May I have a second? Perfect. All in favor of accepting the removal policy that was drafted by Rules and Regulations, please raise your hand and say aye. Aye. Or do either one. You don't have to do both. Any opposed? All right. Thank you. All right. Next up, we have case number 2023-0330. I do not know whether there was actually an opportunity for that subcommittee group to go back and finish that review. And I don't know who. Maybe it was Connor. Yeah. I think it was. We'll wait for him to reach the table so I can ask, because I think that is the right group. Hello, Board Member Strickland. Was your committee going to be prepared to go through 2023-0330 today or in September?
We are prepared, I believe.
Okay. That was the case that we tabled at last meeting, I believe.
Okay, that was the case we tabled last meeting? Okay. And is that from May? I just want to make sure. The May cases?
I am not certain. Let me look back at the meeting minutes, because this is a case we discussed last week, but I think at the end of the day, the subcommittee decided to withhold ruling on it. I am not certain, but I know that that was one of Team Two's cases. Bless you. That was tabled, and I can't recall offhand without. Do you see that anywhere, Stephanie, which one that was?
From April, okay.
Yeah, and I apologize because I have information from May, because our.
Yep, no
but it
problem.
might be April.
I'll see if I can pull it up on my phone here.
And we're positive that's our review committee?
I mean, I'm not 100% positive. It was not mine, and I think the only two folks who managed to get reviews out last time were your subcommittee. Mine got 2 out, but 0330 was not one of them. Mary, I believe your committee reported out last week as well. Well, how about this? If board members Strickland and Younger can look back through their case notes, see which one of you had 0330, and we will pick that back up later in the meeting. Next item on the agenda is review of remaining cases from July meeting that we did not get to finish. I will turn it over to board member Pastor Nathan, because I believe we were on subcommittee 1.
We were. What, just need to find, did we do 217 and 224?
We were able to vote on 217.
We were in the middle of 224.
Yep.
As I recall, Board Member Strickland had 12 or 13 questions regarding that.
Maybe 12.
Sorry. So this was a case where this is case number 2023-224. This case involved an officer who was allegedly discourteous. The incident arose from the officer's refusal to wear a mask when entering a trauma unit. The IG found that based on the body cam that the officer was not discourteous or uncivil, since the officer chose to leave the trauma unit rather than comply with the policy to that anyone entering the unit had to wear a mask, and so the finding was unfounded. Regarding this, our motion, I want to move to accept the IG's finding of unfounded concerning the allegation that the officer was discourteous.
Any seconds? All right, any discussions or further questions?
Just for clarification, this is the case in which, because the officer left, that was the decision where
Yeah.
your
I
subcommittee.
have a second possible motion.
Okay,
but-
great.
But we're severing them.
Okay.
All right, all in favor of accepting the motion and forwarding the recommendation, please raise your hands or say aye. All right, thank you.
Okay, now, the question that we had, and this would be posed, I guess, to the IG, would be the exact wording of the policy. Does the policy require does the policy give allowance, the current training policy, does it give allowance for the officer to leave? Or is it a discretionary matter regarding wearing masks, or does it, we were just not sure what the policy was, and whether we wanted to move to change the policy to require officers to wear masks when entering a trauma unit or a healthcare facility where that was the policy in the healthcare facility. So we didn't know if the current police policy allowed officers to simply choose to leave if they wanted to.
I don't have the policy in front of me. What I will tell you is just kind of going over my recollection, that the CPD policy states that when an officer enters a facility that requires them to wear a mask, that they are required to wear a mask. The fact that the officer left the facility after he was asked to wear a mask, it doesn't speak on that. It just states that when the officer is in the facility, if he's required to wear a mask, then CPD requires the officer to abide by that facility's policies.
Well, we may want to, we request that you would check the policy to see if the officer has liberty to leave, because we might come back with a second motion regarding this, and that is a recommendation concerning whether we want to leave it to officer discretion to just leave, or if this would require some additional training, because this officer certainly felt the liberty to, as he said in your investigation, I don't wear masks, and so I'm leaving.
Okay. I apologize. Can you just give me that case number?
It was number 224.
Okay. We may have that, yeah.
I would do it as a motion as well to refer it back to the IG for follow-up.
Okay.
And we may have an answer for you before the end of the board meeting, because we pulled the policy
Great.
up now. We'll look.
So I'd move to ask the Department of Inspector General to look into the exact wording of the policy regarding mask wearing, and whether it allows an officer to exercise discretion, or is it just simply mandatory?
Thank you.
Thank you for a second. Any other questions or discussion? All in favor, please raise your hands.
If
Oh,
I
go ahead.
can, just to put my 2 cents in, I think that would be an issue if the officer had to be in the facility. For instance, if he had guard duty and he had to be in the facility, he would have to wear the mask. If they were called for some kind of disturbance and he had to be in the facility, he would have to wear the mask. But if he didn't have to be in the facility, I mean, in my opinion, I felt like he can leave and go outside and not wear the mask. But if he has to be there for whatever reason, a police matter, then he would absolutely have to wear the mask. And I think that goes without saying, because the policy states that if he enters a facility where they require a mask, he has to put it on. But if he's there for guard duty, he has to be there, so he has to put the mask on. So I don't know exactly what the call was or why they were there, but he obviously felt like he could leave.
Yeah, this was a stabbing victim that was brought to the trauma unit, and the officer arrived. I don't know if he was required to be there with the victim or not.
And I imagine he came with a partner, and that person may have stayed. Okay.
All right, motion carries. It's referred back to the IG, and if at any time during this meeting you discover the answer to this question, we can interject.
Chair Burns,
Yes,
we have some more information on the complaint 330 if
Thank
you'd like
you.
it.
I was gonna say, it was just assigned back in June, it was like, and it was on Mr. Strickland's.
Yeah, what I'm receiving here on 330, it looks like it is I was sent this email on July 10th, and it's for the August board meeting for 330. Is that the,
This is the office part.
so it must have been, I don't know.
so that would
It's
be
not-
for,
Today?
that would be for today then.
Yeah, I mean, so, yeah, this wasn't a previous case or anything like that, so I'm just,
It was assigned in June.
Oh, okay, so it was assigned in June. It just ended up on, it was on the agenda for last week. We just did not get to it.
I mean, it says, please find the attached cases for the August board meeting.
Gotcha. Right. So it should be ready to go today, right? Or did your committee not meet?
Not for these cases. This was the cases beforehand. Yeah.
I know. So just for clarity, a couple of the review committees did meet and review their July cases for this meeting. I think last week, we moved this case to, because we didn't get to it. Just for clarity, your subcommittee didn't meet and review, you haven't read this case yet.
No, not the
Okay.
August cases.
Great. So
No.
that'll be then moved to September. Stephanie, if you could update the agenda, that would be great. Thank you.
If I may,
Yes.
we have a case number that's been, that our group has continued for a while because Mr. Strickland needed to read it. It was case number 2022-0556, is that correct?
Yeah.
It's been, so that was one.
That's on the list for today, too. It's one
Right.
of the, yeah, we didn't get to last week. Okay, I'm going to let Board Member Nathan continue. 330 will be for September, and we can get to 556 after Team 1 finishes.
This is case number 229. This was a traffic accident with no injury. The complainant alleged that the complaints were that the suspect wasn't cited for the accident, that the suspect wasn't given a breathalyzer despite being intoxicated, and that the officers didn't complete a traffic accident report. The IG concluded, and we concur, that the CPD doesn't have to cite in a non-injury setting, that they did not give the breathalyzer in their discretion because there was no obvious intoxication, and they did not have to complete an accident report. So on all these grounds, the IG's office concluded that the charges were unfounded. I move to accept the IG's report in case number 229 of unfounded regarding all three allegations.
Any questions? All in favor, please raise your hands. Thank you, motion carries.
Case number 234, this was a case involving, the background is that the police performed a raid due to alleged drug trafficking. The complainant's belongings were seized, including a U-Haul truck, a laptop, a phone, and a handgun. The complainant alleged that the CPD won't release his property. The IG found that the U-Haul and the belongings were released, but that the investigation is ongoing. And as a result, the other property belonging to the complainant was part of the ongoing investigation, including the gun and laptop and phone. And so the IG concluded that the officers, both officers should be exonerated regarding wrongfully withholding the complainant's property, and that they were being held in accordance with state law. Our subcommittee agreed, and so I move in case number 234 to accept the IG's finding of exoneration regarding the two officers.
It's been moved. Do we have a second?
Second.
Any discussion? All in favor, please raise your hands.
This-
Motion carries.
Case number 263, the complainant in this case was deaf and had a dispute with his landlord. They contacted the police and asked them to send an interpreter, and alleged that they responded that they didn't have an interpreter, and that they could either text or have their daughter interpret. The complaint centered on the lack of provision of an interpreter for this deaf complainant. In this case, the IG found that the officer did not violate the police directive, and because they decided, the policy states that the officer should first establish whether an interpreter is necessary before contacting an interpreter, and they followed the policy, and so they were exonerated. We disagreed in this case with the IG's finding. We believe that the officer did violate the policy, and it's Police Directive 10.01, which states that sworn personnel should only use a family member, friend, or bystander to gather preliminary information in exigent circumstances. The circumstances weren't exigent, and so they should have pursued getting an interpreter. And second, so that was our first. So we moved to we move that the officer, that this case should be referred to the police chief for either additional training or discipline regarding this officer for violating this policy. So is that the motion that we were?
Can you say the case number again?
In case number 263.
Second.
Any questions or discussion?
Is there a reason that the IG's office did not find this to be a policy violation? I don't know if you all have.
They believe that it was a discretionary issue regarding the officer's use of the interpreter, so that they should respond to see if assistance was necessary. But in this case, the policy states that an attempt to establish communication and determine the need to contact qualified, that in this case, there was enough evidence to say that this person did need an interpreter and should not use a family member. They requested it when they made the complaint, and then they were told, the complainant said he was deaf, and also they said that when they were making the complaint to bring the officer.
And is there, and so you all disagree with the finding of the IG's office in this case that you all do find it to be a policy violation?
Yes.
Okay. What I'm just trying to get a sense of is where the disconnect is in terms of where the IG came in and said it was not a policy violation. Where is the divergence of where you think it's a policy violation and the IG's office says it's not a policy violation?
The IG thought that well, I can let the IG speak for themselves, but I think that, do you want to report, or would you like me to?
So based on just the review of the policy, also reviewing the notes and stuff from the investigator, the officer did arrive at the scene and was talking to the complainant. They also offered to, take notes, had a notepad that he could communicate with the complainant. This was an issue where I believe the complainant was possibly involved in being evicted from the property. And so the complainant was asking for an interpreter because he wanted an interpreter there, and the officer was able to communicate. And just based on the policy, it does allow for the officer to be able to communicate, and if the officer is not able to communicate with the complainant, then an interpreter can be requested.
Yeah, I think part of our disagreement with respect was that the officer was using the complainant's daughter, if I recall, and the policy says that the only time that one should be using a family member is if, there are dire circumstances, they call it exigent circumstances. But in this case, there was time to get an interpreter, and they were using this third-party family member, so we thought that the officer was violating the policy.
But the family member was already present and interpreting at the time when the officer was there. It wasn't that, the officer could not communicate with the person at all, the family. I know, I understand what you're saying. I just wanted you to know that the family member was also present and doing the interpretation throughout the whole process.
We knew that the
Yeah.
family member was present. Yeah, it was clear that the family member was present, but when there was a request for the interpreter, we didn't think the circumstances were exigent to overcome the request for an interpreter.
And I think that one of the things we talked about is during a court process, for example, if an interpreter is needed to help a witness or someone like that, it's generally not acceptable practice to just grab somebody in the courtroom and say, hey, you interpret. Like, that's the whole reason why there are interpreters who have to go through a process, education-wise, licensure-wise, to ensure that the information that's being relayed is accurate. And so that was our concern is, beyond this one incident here, let's say that it's someone who is speaking Farsi, and we haven't brought an actual interpreter in, we've instead just relied on the person's child to interpret for them. So this is not simply just, here we have a person who speaks ASL, needs an ASL interpreter. This could be for any, if this scenario had been repeated with any sort of interpretive need, we think it's a little problematic for at least if the policy allows it, to be lax enough to allow an unlicensed, untrained family member to be the person standing in the space of ensuring that, especially when it comes to law enforcement, that legal information is being interpreted accurately.
So thank you for that. I mean, to me, that sounds, though, that might be a different, I mean, that might just be a call for a policy change or clarify.
Well, we
gonna
have
do
a second motion to have a policy change. We're saying even with respect to the application in this case, that the officer was wrong and that the allegation should be sustained. So we're moving, so let me again state the motion. Our first motion is that the officer did violate Police Division Directive 10.01, and that the allegation should be sustained. So I move that in case number 263.
And I think we do have a second already. Any other questions or discussion?
Yeah, I mean, I think the context of saying that there's a policy violation here, and then the next step is to, I don't know, further clarify the policy or further, I don't know what the next step is.
You'll hear the next step.
But I want to make sure I have the context for voting, because it seems that if you're in that situation and you've been found to violate a policy, and then they follow that up with, well, let's clarify that policy. To me,
So
it seems like there might be an issue with the policy in the first place, or.
The issue wouldn't be a clarification of the policy. We're asking for a change of the policy, that when someone, we want it to be a rebuttable presumption, but I don't know how far down the road you want me to take the second motion.
Yeah, I think our subcommittee did not think, based on the information in the report, that the exigent circumstances there to justify not having an interpreter existed. So that's why we think there's a violation of policy. In addition to that, we're going to ask that the policy be changed so that there's a rebuttable presumption for an interpreter to be brought, unless, and then there can be circumstances which overcome that presumption. But right now, it's written as a presumption to not have an interpreter, to only have one when there's this overwhelming need to, and we think it should be inversed. So that's what our second motion is going to be, is to change the policy to require interpretation unless XYZ.
In other words, when there's a request made for an interpreter, that an interpreter ought to be provided. If somebody texts the police,
Yeah.
an interpreter ought to be provided unless there's a reason why, in this instance, an interpreter, we know this person or something else, that we're not going to provide an interpreter. But even under existing policy, we think the police, in this case, violated the existing policy.
And then also to add into this, I'm hearing this probably the first time, and I noticed that it is probably a violation of civil rights, Title VI, which prohibits, to have a minor or someone who has not been trained in providing appropriate interpretation. And when an officer, in this case, is being requested by a third party or second party to have an interpreter, civil rights mandates that the officer should be at least request an interpreter.
Well, and I appreciate that. And I think where I'm trying to look at this is how is our claim going to have any impact or outcome when the team of investigators in the IG's office has reviewed this, doesn't find a policy violation, and we brought up some additional reasons as to why we might see it to be a policy violation, versus us referring it back to the IG's office and based on this additional context. Because to me, and happy to go forward with this, but to me, we make one recommendation one way. The IG's office is going to send their report over to CPD, attach our disagreement or additional policy violation, and then CPD is going to go through their process and come up with their recommendation. they're going to see that the Civilian Review Board and the IG's office is split. Our Civilian Review Board does a review of the IG's office that's doing the investigation in the weeds and finds that this is not a policy violation. So to me, we can go ahead with this, but I'm not, to me, I'm a little worried that it's not going to have much of an impact, is all. That just by the, at least, again, we talked about this last week. We don't even know where the impact is going, but I would feel more comfortable if we had a stronger set of whether we had the policy violations very specific, laid out, similarly to the ways that the IG's office will lay it out versus us saying, well, we just think it's a policy violation and this is why. To me, that doesn't really hold. I don't think it will hold ultimately.
Madam Chair?
Yes.
So one thing I did, because we have been reviewing the reports that we get back from CPD, and we are putting together some stats to be able to bring to the board. When the reports are approved or when they go from here to CPD, CPD looks at all of the reports and they either agree or disagree. But their agreements and disagreements are all based on policy. So they're going to look at the policy also. So whatever recommendations, if there's a recommendation that the board feels that either the policy needs to be reviewed or maybe not have as much discretion on the officer side, maybe they want the policy to be a little bit more narrowly to the point that when a person requests a person that, the policy recommendation might be if it's requested that request be honored. So just so that you understand, even when it goes to CPD, they still look at the policy too. So it's not, and we have had times that we had a policy which we could not find, and that was a directive that came out from the COVID. We couldn't find it, so we sustained the officer because we could not find the policy. When it came back from CPD, CPD did find the policy, although I do want to add that we did ask IAB and we did ask the lieutenant for the policy. But anyway, when it came back, they actually non-sustained the conduct, and the reason they non-sustained it was because they did locate that policy. So just understand, whatever the board's recommendation is to our recommendations, rather policy, they look at everything. So it's not like they take one over the other. Everything they do will be based on what policy is. But what we can do that I think sometimes is a question is we can always forward a copy of that policy. Like now, because there's a question, we can always get a copy of that policy, forward it to the board for the board to review it. And the board might look at what we looked at and said, you know what, we understand what the policy states, but we feel maybe there's a change that should be in that policy that would dictate when a request is made. So just wanted to bring that.
Yep, thank you for that. And I will say again, the IG is looking into whether we can have access to Power DMS, because that will help the board to actually be able to read policy when they're reading cases. Again, also I would note that even though we don't know what's going to happen with these recommendations, but we do know that even if at the end of this report, our motion for this and recommending that this specific officer have additional training may not result in him getting that training. But our recommendation that the policy be changed to have a presumption for an interpreter being brought may be the thing that does get accepted. And so,
That would be a second motion.
yes.
So we have a motion on the floor and a
Yes, we
second.
have, exactly.
Just for clarification on the case, there's a discrepancy. The officer was saying that he was not asked directly for assistance, correct?
No.
That it was the complainant asked the dispatcher?
No.
No, the complainant asked for an interpreter.
To the dispatcher or to the officer?
To the officer.
Okay. So there's just a discrepancy. The officer stated that he was not asked for ASL assistance directly, correct? So, like,
He was-
paragraph above the conclusion.
Let's see. Well, he knew that the ASL assistance, that he was aware that there was a request for ASL assistance. And then, so he said, the paragraph above the conclusion, he wanted to respond to the scene to determine if ASL assistance was necessary. So he was aware when he arrived on the scene that there was a request for ASL assistance.
And I ask that simply because in the policy that's listed here, states an attempt to establish communications and determine the need to contact a qualified sign language interpreter. And he was writing things down and communicating when the female, the family member, I guess, showed up. And so in the policy isn't, if it's to determine the need, are we saying he wasn't determining the need, or?
We're saying that the policy also adds under 1001 that they should use a family member or bystander only in exigent circumstances. And that's in mine on page 3, it's under the analysis and findings.
At the beginning of the summary, it states the complainant explained that he did not want his daughter to interpret for him, and he wanted a professional interpreter, and the officer should provide one.
And part of the second motion, once we get to it, is specifically about that. The officer makes the determination, that's pretty subjective. Whereas if you have a policy that presumes an interpreter will be called, that's a lot cleaner, unless the person overcomes that presumption and says, no, I don't need one. Like, I'm good with whatever situation we have.
Or, yeah,
So-
clearly understands and clearly
Yes.
knows what's going on.
So I'd like to call the vote. We've got it on the floor. We've had our discussion. All in favor of accepting the recommendation of the subcommittee, please raise your hands. Any opposed? Any abstentions?
Okay,
Thank you.
then we have a second motion in case number 263 to recommend a change in the directive to have the request for an interpreter to be a rebuttable presumption, so that instead of the police having to, it would be, I'll just leave it there, that it would be a rebuttable presumption that when a request is made for an interpreter, that an interpreter be provided.
Any questions or discussions?
Yeah, I still don't quite understand the current policy. So what do you mean by rebuttable presumption here?
That the rebuttable presumption would mean that if a request is made to the police or dispatcher for an interpreter would be provided.
Automatically.
Automatically, unless when the police arrive, they say, this person clearly understands, or this person said, no, I really don't need the interpreter, or some other set of facts, unless circumstances outweigh that. In this case, they have to establish a need for an interpreter. We're saying the presumption ought to go the other direction.
It's just flipping the presumption.
Yeah, is there a way, I mean, I generally think this is a good policy recommendation. I'm just trying to get a sense in terms of how we can, I don't know if we work to get this policy. I don't know if our council or others have thoughts in terms of if we make a policy recommendation, how specific do we need to be in our wording to get across what we're trying to get done here?
That's up to you.
Well, yeah.
And might I just say, I don't know that with any of our recommendations, we need to or should get into the weeds of drafting.
Yeah,
Like,
we're not
the
drafting a
Legislative
piece of
Services
legislation,
Commission.
yeah.
And that, I feel like that would bring us a little too far afield of what we can do, which is recommend. Mr. Tobias?
Well, I was going to say the other thing, yeah, you're making a general recommendation of policy. If the chief of police or public safety director agree with that, they have counsel that they'll consult to draft the specific language of that policy.
Okay. Yeah, I just want to make sure that it's clear in this instance then that the idea is that the policy right now is not, okay, and so we just want to make
The burden of proof right now rests with the person asking for the interpreter, we want to shift the burden so that the interpreter is automatically given unless the police can overcome that by some other set of, facts.
Okay.
That's sufficient.
Okay. Cool.
So
All right, we've got our first, second. Any other discussion before a call to vote? All in favor of recommending the change in policy? Thank you. Motion carries.
Okay, this is case number 289. Circumstances where that an officer was responded to a call from elementary school in which parents were alleging that their child was bullied. The complainant in this case is the principal of the school, and they alleged first that the officer came to the school regarding a matter that was of no concern to CPD, and so they shouldn't have been at the school. Second, that the officer was not assertive enough in responding to cursing by the parents. In this case, the IG found that it was appropriate for the officer to respond to the school. He was dispatched there on a call for service, and that CPD often acts as a mediator for these kinds of situations. So the Inspector General found with respect to whether the officer should have been there, that he was exonerated, and second, that the officer acted appropriately and effectively, and that the claim of the officer not being assertive enough was unfounded. We agree with the IG's finding, and so I move in case number 289 to accept the IG's findings of exonerated as to allegation 1 and unfounded with respect to allegation 2.
So moved. Is there a second? Second. Any questions? All in favor, please raise your hands. Thank you. Motion carries.
This is case number 297. This was a traffic stop due to erratic driving. It was an allegation of an unlawful arrest and also an unreasonable use of force in a traffic stop. The IG concluded that this was not an arrest, it was a detention due to erratic driving. And so with respect to an unlawful arrest, the IG found the officer to be exonerated, and the body-worn camera demonstrated that there was a use of force, but it was not excessive. And so with respect to allegation 2 of an unreasonable use of force, the IG's finding was that the officer should be exonerated. The subcommittee agreed, and so I move in case number 297 to accept the IG's findings with respect to both allegations of exoneration.
Thank you. Any questions or discussion? All in favor, please raise your hands. Motion carries.
I think that's it.
Yep, I think that then leads us to Team 3.
Starting with, are we starting with 23-1124?
Are we still on 5?
We did not finish the cases from July meeting, so let me see. Well, maybe this isn't Team 3. Who has 2022-590?
That's me.
Okay,
Our
all
team.
right, sorry, Team 2.
Is that right?
Mac was ready to go. He was ready to go.
Work. I'm telling you. I think we need a name. I think we need to name these.
Sorry about that, Mac.
Differently in terms of like cases from July meeting, because I kind of get a little confused as well. So we will start with this is our investigation review and report out overview of these cases that we did not discuss for the month of July. I'm just going to list the cases in which we agree with the subcommittee or the Department Inspector General recommendation. We'll start with those first. So the first one is case number 002. And this is on January 3rd, 2023, the Department of Inspector General received a complaint of misconduct via the hotline. The complaint alleged that on January 1st, 2023, he was escorted by Columbus Division of Police officers when they told him that he had to pay the fees of a club he was leaving or he would go to jail. The complainant further alleged that the officers were rude and disrespectful to him, that they broke his girlfriend's bracelet when she was handcuffed, and that her wrists were bruised and swollen from the handcuffs. The Columbus Department of Inspector General investigation was comprised of the following: a review of the club's surveillance footage, body-worn camera footage of a witness officer, statements, parentheses here, complainant, club owner, and 5 officers, and a review of CPD policy and procedures. The investigation found that the officers were within CPD policies and procedures throughout their interactions, and therefore it is found that this complaint is closed with a founding of unfounded for allegations. I'll walk through those. The first allegations is allegation 1, that the complainant alleged that he was escorted or extorted, it says extorted here, by CPD officers when the officers indicated he would go to jail if he did not pay his outstanding club's bill. CPD is indicating that, or Department Inspector General is indicating that that is unfounded. Then there's allegation 2. Complainant alleged that his girlfriend's wrists were swollen from being handcuffed. Department Inspector General is recommending exonerated. And then allegation 3, complainant alleged that his girlfriend's bracelet was broken by CPD officers when she was handcuffed. Recommendation 3 there is not sustained / inconclusive. And then allegation 4, complainant alleged that CPD officers were rude and disrespectful. The recommendation there for the Department of Inspector General is unfounded in that case. This is an extensive investigation memo that walked through the process through the surveillance footage and the camera, in our subcommittee found that the Department of Inspector General's review here is upheld here. So we would actually agree with the recommendations of the Inspector General in case number 002.
Is that a motion?
It is a motion to accept the IG's recommendation in case 002.
Second.
Any discussion or questions? All in favor, please raise your hands. Thank you.
Case number 0045. On January 19th, 2023, the complainant filed a complaint alleging misconduct by CPD officers. The complainant alleged that she was racially profiled, causing her to be pulled over for a traffic stop. Additionally, the complainant stated guns were drawn on her during the incident. The investigation consisted of a review of body-worn camera footage, computer-aided dispatch report, and statements from the complainant involved officers and CPD policies and procedures. In allegation 1, that the complainant alleged she was racially profiled by CPD officers, causing her to be pulled over for a traffic stop. The investigation found no evidence that substantiated the complainant's allegation. Therefore, it is recommended that this allegation be closed with a finding of unfounded. In this particular case, there was a review where the officer indicated he wasn't able to see when he pulled this person over for a traffic stop, and so that the finding there was that the racial profile was unfounded. Allegation 2, the complainant stated that CPD officers had their guns drawn on her during the traffic stop. The investigation revealed that when the officers initially approached the vehicle, their weapons were not drawn. Officers drew their weapons after instructing the passenger several times to show their hands and to stop reaching towards the floor of the vehicle. The officers' actions were in accordance with CPD policies and procedures. Therefore, it is recommended that this allegation be closed with a finding of exonerated. Additionally, the investigation revealed that an officer used profanity while giving an individual a directive during the traffic stop. It is therefore recommended that the officer's action be sustained, as their actions were in violation of CPD policies and procedures. So again, allegation 1, that the complainant was racially profiled, was found to be unfounded. And then allegation 2, complainant stated guns were drawn during the traffic stop. the recommendation is exonerated as guns were drawn, but that was after instructing passengers several times to show their hands and stop reaching towards the floor of the vehicle. And then there's an additional allegation, Department Inspector General allegation of sustain for violation of policy for the use of profanity. So our subcommittee agrees with these recommendations and we'd like to make a motion to accept the IG's recommendations for case number 230045.
Any questions or discussion?
Just one question, did the IG add the allegation 3, was that at the IG's?
Yes.
Okay.
Yes, that was a sustained allegation.
Mhm.
Yep.
Any other questions?
And I would say for the discussion purposes, this is something where, in this case, it did not seem to be an issue in terms of the racial profiling. But again, stressing the importance of kind of data collection, of seeing any potential patterns or issues, right? If somebody has consistently allegations or complaints against them about racial profiling and those types of pieces or those elements, it would be important for us to know so that we can weigh in on a set of on that particular complaint. In this case, it does not appear to be so, but I do want to figure out a way to build and track those types of complaints so that we.
With respect to a particular officer?
Yes, with respect to a particular officer, also just like the number of complaints. I know we've got some of those, the racial profiling cases, but it would be helpful to know if there have been a kind of a pattern, if there's any patterns that develop. But in this case, it doesn't seem to be an issue here. It's unfounded. And so, yeah, no further discussion.
Kyle, did you mention why she was stopped in the first place?
I did not. I'm gonna pull that back up. And that's part of, I just want to make sure as I'm getting all these pieces together here. Let me see that, make sure that's set up here. Okay. If anybody has that pulled up specifically, that'd be great as I'm trying to. Reminder, this is case number 0045. I've got it here. Yeah, it looks like for speeding is what the officers were following the vehicle. One stated the vehicle was driving 60 miles per hour. Is there a reason why you were driving 60 miles per hour down High Street?
Didn't stop at a stop sign, didn't use a turn signal.
Yeah, there were a number of.
Okay.
Yep.
All right, we've got a motion and a second on the floor. All in favor, please raise your hands. All right, motion carries.
This is case 00230090. I'm just going to read the summary. On February 2023, the complainant filed a complaint with Department of Inspector General alleging misconduct by CPD officers. The complainant alleged they witnessed a CPD officer using his phone to take pictures of license plates of cars parked at the complainant's apartment complex. The complainant feels the officer had no right taking the pictures, and this was a violation of his right to privacy. After the review of body-worn camera footage and a statement conducted with the officer and a review of CPD policies and procedures, it is recommended that the allegation that the officer took photos of his license plate be exonerated, as the officer's actions were within CPD policy and procedure. And I know these have kind of shifted, these reports have kind of shifted over, but part of that summary too would be able to kind of explain specifically there the language, which is later explained, which is that this particular officers would, they were reviewing an ongoing situation, and they were taking pictures of multiple, they were trying to track down multiple license plates, and were not specifically targeting one person is what the review found. And so that's where the recommendation is of exonerated, and our subcommittee agreed or would recommend accepting the Department of Inspector General's recommendation here.
Can you form it in a motion?
That's our motion. Yes. Motion to accept the IG's recommendation in case number 0090.
Any seconds? Any discussion or questions? All in favor of accepting, please raise your hands.
Yeah, okay.
Motion carries.
Okay. Case number 0095. On February 6, 2023, there was an allegation of misconduct. The complainant alleged that an officer denied a white female reporter an interview, yet granted one to a black male reporter an exclusive interview about the, quote, Jump Out Boys. The complainant further stated, quote, exclusive interviews are a direct violation of CPD policy, end quote. The Columbus Department of Inspector General conducted a statement with the officer named in the allegation and confirmed with the Columbus Division of Police Public Relations Advisor that the interview given was not exclusive and that this officer did several interviews with several outlets over 2 days. Furthermore, the, quote, white female reporter, end quote, was provided with a statement when she asked for one and all follow-up questions were answered. Therefore, the Columbus Department Inspector General recommends that this allegation be closed with a finding of unfounded as an exclusive interview was not granted. The one note that we had in this was it's not dispositive on changing the situation because the facts are there, but we did have a note of if there was a particular reason that the complainant was not interviewed by the Department Inspector General in this regarding this complaint. I know that seems to be at least most of what we've seen. There's typical practice of interviewing the complainants in some form. And so based on our review, I don't think that was indicated that the complainant was interviewed. So I just wanted to bring that up if they were interviewed, or if not, is there a reason that seems to be different than the standard practice?
So in this case, we do have the investigator here that you can ask, but most of the time we do reach out to interview the complainants. However, all of our complaints are not, there's not always contact information that's provided. Sometimes we do get phone numbers, sometimes it's emails. They always reach out, if it's an email, to try to interview complainants. A lot of times the investigators will get emails back to say, everything is included in my complaint. So, yeah. But I think this case, Scott was the interviewer. He was the investigator on this case, so he can probably answer your question about this particular.
Yeah, I just want to clarify the question real quick. Are you speaking specifically about the alleged white female reporter that was not given an interview, or our complainant wasn't interviewed by us? To clarify.
Yeah, either is there a reason that you did not reach out to the complainant to follow up, or to the alleged victim of this complaint?
Sure, yeah. The complainant provided everything in an email. We didn't get any other contact information besides the email. This is how this complainant preferred to be contacted. Everything that we needed was provided in that email, so we didn't feel the need to contact them for any further information. No other information would have changed the outcome of this investigation based on the policies that we reviewed and the statements that we took.
Yeah, it's helpful. I mean, I agree generally in terms of, in this particular instance, in terms of a practice of just generally reaching out to the complainant for, I don't know, to be interviewed or not. I just wasn't sure if that determination was made, but that is something that I think is just something to consider, even in situations where you think that it's not going to be dispositive, that nonetheless that there is that interview. Because I've noticed that in the vast majority of cases, complainants or subject of complaints are interviewed. And so I was just wondering what the difference was in this case.
Oh, I'm sorry.
No. So do you understand, though, that in this case, the complainant did not provide any, they were anonymous. They did not provide.
Oh, is that what that is? Is that what that?
Contact information.
Is that what that is? Okay. That's helpful. I mean, the name looked
Well,
not.
the name is there, but they didn't.
Yeah,
they didn't
well, I
give
mean,
us
the
any-
name didn't look real either, but,
Yeah,
okay.
yeah.
That's good to know. All right, that's helpful. Thank you. I appreciate that. But that's, but yes, that makes sense to me. Oh,
I'm sorry.
yeah.
Point out as well. We do make a practice of contacting the complainant for every complaint that we get. All the investigators reach out each time we are assigned a case. That's one of the first things that they're required to do. So each complainant is contacted if we have the means to contact them. We just may not do a full interview with them. It may be just a quick phone call to say, hey, do you have any other additional information? And if not, we won't include that as an interview just because.
Oh, I see. Okay.
Yeah.
Yeah.
But each person is contacted and each person is given the ability to do that if necessary.
Okay, great. And just for the purposes of folks who are kind of listening in, don't see the case, I mean, it seems to be here an anonymous complaint or somebody filed this complaint, not clear whether that's their real name or not. Nonetheless, folks want to do that. It could be. Either way, we accept the IG's recommendation in this case of finding of unfounded, as there was not an exclusive interview granted. So that's our motion, 0095, to accept the IG recommendation of unfounded.
Any other question or discussion? All in favor, please raise your hands. Motion carries.
On February 8th, 2020, this is case number 0115. On February 8th, 2023, the Columbus Department Inspector General received a complaint from the complainant alleging police misconduct. The complainant alleges that her son was in an automobile accident. The complainant alleges she was told by officers that she would get a traffic report, and recently she found out there was no traffic report completed. After review of the computer-aided dispatch report, body-worn camera footage, and statements given by the complainant that she no longer wanted to pursue the complaint, the investigation found no evidence to substantiate the complainant's allegation that the officers told her they would complete a traffic report. Therefore, it is recommended that this allegation be closed with a finding of unfounded. And there were some details here about how certain reports are completed and whatnot. And then also, I do want to stress, I think it's important that even in situations in which a complainant maybe says that they no longer want to pursue a complaint, the Department Inspector General's office will still look through the complaint if there's any potential violation. Here, it was found that the recommendation is unfounded. So we accept the IG's recommendation, so that would be our motion for case number 230115.
Any seconds? Any questions? All in favor, please raise your hands. Motion carries. Thank you.
This is case 0116. This is on February 2023. The complainant filed a complaint with City of Columbus Department Inspector General alleging misconduct, where the complainant alleged that officers used excessive force when she was ejected from the town hall bar on February 5th, 2023 at 1:06 a.m. The complainant stated she was picked up by two officers and dragged to the sidewalk. The Department Inspector General reviewed and investigated the complainant's allegation that comprised of more than a review of 2 videos, an interview with the town hall bar manager, the involved special duty officers, and the body-worn camera footage. The Columbus Department Inspector General made several attempts to reach the complainant to obtain further information regarding her allegation and determined the exact date of the video footage that she submitted to the Columbus Department Inspector General for a review. As of April 25th, 2023, this is an earlier case, the Columbus Department Inspector General had not received any response from the complainant. The investigation found no evidence to substantiate the complainant's allegation that she was picked up by officers and dragged to the sidewalk from the town hall bar. Therefore, it is recommended that the complainant be closed with a finding of unfounded. And in this case, there's a detailed explanation of kind of the footage that was provided and walk through the process where there was no evidence to substantiate the complainant's allegation. The recommendation here is unfounded. We would move to accept the IG's finding of unfounded, recommendation of unfounded in case number 116. That's our motion.
Any second? Any discussion? All in favor, please raise your hands. Motion carries. Thank you.
So this is our final of those cases here. This is case number 0590. And this is a case where on December 20th, 2023, the complainant filed a complaint with City of Columbus Department of Inspector General alleging the actions by Columbus Division of Police taking 4 to 5 hours to issue an Amber Alert as misconduct. This is the case that was widely known that the complainant claims that her twin nephews were kidnapped on December 19, 2022, and the Amber Alert was not issued until 4 to 5 hours later. The complainant claims that had the Amber Alert been issued sooner, it could have prevented the suspect from driving to Dayton, Ohio with one of her nephews. After review of the computer-aided dispatch report, the preliminary investigative report, CPD policies and procedures and statements, the Department of Inspector General recommends that this allegation be closed with a finding of exonerated, as the investigation found that the officers were supported by CPD policies and procedures. This was an extensive, for those of you who had the chance to see, this was an extensive investigation memo. We have further questions about it and concerns just about the process. Before kind of making any particular determination. So we just kind of requested further discussion here. There's a set of questions and notes that we have, which is, has there been a full after-action review of this situation and the various agencies involved? Based on the reporting here, it seems that there are conflicting statements on what should have occurred in this situation, and just kind of at a high level, you know, you've got a situation where there are multiple agencies that are involved in the process of issuing Amber Alerts, and certain steps were taken where somebody was waiting on more information and didn't get the information, and others were trying to get that information out, and then things got sent back and then sent forth, and ultimately this was issued, but not until 4 or 5 hours later, what is alleged here. Ohio State Highway Patrol is also involved in this. Then you have the national system in terms of dealing with Amber Alerts. So to me, it seems like something should have happened differently here. And the question I also have is, are the involved agencies considering a change in certain policies and practices? And so I don't know if the Department of Inspector General has more insights to discuss this very lengthy case. But I'm just a little concerned here in this instance where there's a finding here of exonerated, but it seems like something went wrong along the way, and I'm just trying to figure out how that determination was ultimately made. So I just wanted to hand it back to the IG's office to maybe provide some additional background on this particular case on 0590.
If I could, just because I've read these cases as well, wasn't this, when the call was first coded, it was coded as a carjacking first? And as a carjacking, at least the way the system is set up, and I don't know the details of the system, but you can't attach an Amber Alert to a carjacking. Like, it has to be coded as a kidnapping in the system first before an Amber Alert can then be tied to it. Is that correct?
You're absolutely right in how when situations like this occur, how it's reported, how it's entered into the system, and once it's entered into the system, whether or not an Amber Alert can be attached. What I can tell you is that the report kind of goes through everything that CPD did as far as collecting all the information, how all the information was supplied, how everything went through records and was entered. So there was just maybe I won't say it was a misstep, it was how information was entered. What I can tell you is at the end, CPD did everything that they were supposed to do within policy and procedures, along with working with the Ohio State Police to make sure that everything that they needed in order to get the Amber Alert issue was issued. I can tell you that based on the conversation that one of the investigators had with upper leadership with CPD, that more people were trained so that when it comes to being able to enter the codes that need to be entered for the Amber Alert to be issued, that they are aware of that. But based on everything that CPD did, they followed policy and procedure, and the Amber Alert was not something that is issued by CPD. It's entered by Ohio State, but everything that CPD did as far as gathering information, all the information that needed to be gathered, all the information that needed to be entered in order for it to be entered up under the correct code for an Amber Alert to be issued was done within policy and procedure.
The one of the concerns, so thank you for that, the explanation in terms of that kind of review process. One of the concerns is that it does seem, though, that there was conflicting, even within CPD, kind of either conflicting, somebody said something should have been done and somebody said no, or, yeah, I'm just trying to get that, some clarity on that particular instance, that it seems like there were some conflicting thoughts there. I don't know.
If I could.
Yeah.
I think that maybe the issue was that there were different officers interviewed at different levels. We spoke with responding officers who came out. We spoke with the sergeants who were on scene. We spoke with other detectives, officers, and sergeants who were within the Investigations Bureau, all the way up through the commander, including others with different agencies. So it's not necessarily that those statements were conflicting. I think it was more so that those statements were differing because they had different responsibilities at those different levels. As far as we found, everyone that we reviewed and every person that we did talk to that was the focus of this investigation, or any person who could have been the focus, we reviewed those policies based on what their job should have been at that time and what policies they would have been looking at. For the investigators, it was the Investigations Bureau SOP. For patrol officers, their own SOP and directives too. So each person was looked at individually to ensure that they were following the appropriate steps that they should be at their level.
And so thank you. And has CBD made any, I don't know if they've made any statements regarding what their, I mean, because it still does not seem clear. Obviously, something happened in a way that the miscommunication or however it went down, that this should have been sent out sooner, and others admit to it should have been sent out sooner, not necessarily finding exactly who's to blame necessarily or what that might be. And so I don't know if there's been an after-action review or some sort of discussion of, so that this doesn't happen in the future. That was one of the questions that I have is what is the outcome? Do we have a sense of that?
We don't have a full sense of that. That's more for CPD. We didn't dig too much into that. When I did speak with one of the commanders, when we did a statement regarding this, they did mention that they did train more people to ensure that there was more people who were available to handle these types of things, because there are only limited people who were able to put these things in particular in the Records Bureau, records technicians, who put these things in and code them appropriately so that state police can handle those things. With that said, I think there may just have been that disconnect between state police and CPD. I don't think that on either end that was their issue, but I know that CPD did bring that up at that statement that was given, saying that they have discussed those things and that is on their mind. I don't know what they've done beyond that.
Okay. Does anybody have further thoughts? I mean, this is something that we were concerned by. I mean, the other piece here is that there's an allegation that it's an allegation of misconduct of CPD because it took this, 4 to 5 hours to issue an Amber Alert. And the subject of the allegation here is one of the detectives who was the lead investigator on this case. I was wondering why that determination was made, that the allegation would be against that one detective versus maybe other entities or other individuals handling that case. So is there a reason that determination was made?
The reason we selected the detective as the focus is because the detective was the one that was gathering all of the information. He was responsible for gathering all of that information and for all of that information being focused and directed to where it needed to be directed to be entered into the system. So again, I do understand the concern. There was a lot, and I'm sure you had the chance to read the report, there was a lot of parts that was incorrect, but it was not on the officer's parts. Some of the information came from not getting the full description of what actually occurred, who actually was in the vehicle, getting the information about the vehicle, having the information sent out. There was just a lot of information that played a part in how long it took for the information to be gathered and entered into the system. So I don't know, for me, I can't answer
Yeah.
why it took the time that it took. That would be something that CPD would probably be able to answer. If you're asking for the time, is there a time frame as which it should take for an Amber Alert to be issued? But what we can tell you is based on all of the people that played a part, from the officers arriving to the scene, gathering the information, that information being given to the detective gathering that information, the detective talking to state police and providing all that information. We have all of those documents, how all that stuff was being documented, how it was being talked back and forth. There was not a time where we felt, looking at the investigation and the people we talked to, that nobody was not working. Everyone was working diligently to gather the information that was necessary for the Amber Alert to be issued.
Yeah, and the concern I have is that there's a note in the report. I can't, I'm not really figuring out page numbers, but this one is about one of the sergeants, where the footnote is 26. Like that's the page that's
Okay.
the closer you're going to be able to get. It's right after footnote 26. Where it says the sergeant stated he believes there was some confusion within the records unit regarding what information should have been sent to Ohio State Highway Patrol and what they needed to do. There were several new employees in the records unit, and they may not have been familiar with the process, and a supervisor was not available. So that kind of line or set of lines seems like something should have happened there. So that to me is where I'm a little concerned as to should there have been a supervisor? Is that it? Was it in fact the case that there were several new employees and they weren't familiar with the process, or did they answer that differently?
Okay.
That was part of what the sergeant had stated in their statement. That wasn't information that we found to be, I suppose, usable information for what we were looking at. When we were looking at those policies and we were interviewing all of these people, a couple of factors came into that. One, our office doesn't have oversight of the civilians who work in the records technician or the records office. So we didn't talk with anybody specifically in there, to my understanding. I know the investigator's not there to answer that question. But the other thing, too, is that the information that he provided in that statement was his opinion of what should have happened or what should have, been sent to where. That, again, was something that we reviewed to determine, was that in fact the case? Should that have been sent sooner, quicker? And the policy determined that that was not an issue that we were going to be looking at because it was not stated specifically in that policy how quickly something should have been done.
So my concern is that if those employees in the records unit were not interviewed, and he says they may not have been familiar with the process, that you could have employees in the records unit that says, oh no, I'm familiar, or you could have had them say, oh, actually, I wasn't familiar with the and I hope I wasn't the one, right? So I'm just trying to get a sense of, a sergeant stated that could have been an issue, and we still haven't determined where the disconnect happened. Maybe it happened, across agencies, but at least within CPD, whether or not there was a disconnect, there's a statement here that indicates that could have been part of the disconnect.
Well, I do know that when I spoke with the supervisor in the records section, that we talked about the coding of how information has to be entered into the system for an Amber Alert to be issued. There were several different codings that was entered initially, from it being initially being a carjacking to a missing person versus a kidnapping. And I would have to do some more research to give you clarity. I do remember that. There has to be a specific code entered for the Amber Alert to be issued. And the problem is at the time, is that the code was not entered correctly, but once the records section was notified that they had to change that for the Amber Alert to be issued. But what I can tell you is I think we would have to probably pull up the report that I believe when the Amber Alert was issued, that the Ohio Highway State, yeah, they actually did issue the Amber Alert, even though the coding that should have been entered by the records was not issued. They went through another agency to have that Amber Alert issued.
Yep.
And then once the coding was rectified, then it was entered, then they were able to transfer the coding over. But that didn't stop the Amber Alert from being issued. So the other thing that I would say also is, for us, it's really important. We want to be able to answer any questions that the board has, but we would always ask that if the board has a questions or they have a disagreement, that they give us that ahead of time, so that if we need to do a little research to kind of get the specific wording, we want to be able to do that.
Yeah.
But again, reading the report, and it was very detailed, we do know that Ohio State, again, did issue the Amber Alert, and that even though the coding wasn't rectified right on time, that didn't stop the Amber Alert to be issued. It was issued, and the report talks about the agency that issued it. Then once they were able to get that code rectified, how it was changed back over to, what needed to be entered into the system. So again, I would just like to reiterate any questions that the board has about a report, so to help the board be able to, either make the decision whether they agree or disagree. If they would give us those questions ahead of time, then we would definitely be able to kind of answer the questions.
Yeah, it seems like there may be some disconnect there because this was part of our review committee report out that was submitted on July 18th in terms of after our meeting, or maybe later than that, but ahead of last week's meeting and then for today's meeting, and there was a set of the notes. Maybe it wasn't framed in specific questions. And so that's kind of the indication. I don't know if maybe that didn't get to your office, but just making sure that we're figuring out that process. Maybe we can reach out directly versus kind of the
If I could just
process.
interject a
Yeah.
couple things. One, I think probably it sounds like there might be additional questions that can't be answered today because they'd have to go back and look. And so I might suggest motioning to send it back to the IG if there are those. Second, I would say too, a lot of our subcommittees the chair of the subcommittee has just emailed IG Hendricks directly to bring attention, because of the fact there's like 30 reports coming back to them. And I don't know if your report said agree or disagree at the bottom, but I don't know how much time folks have to reread all of our worksheets prior to the meetings, but when there are cases that we have questions about, I know our subcommittee tends to reach out ahead of time and send an email to flag it and say, hey, case number this, here's the specific question we have in advance of this meeting. So for sake of moving forward, I think that's a good practice to engage in if review subcommittees have questions that you want them to be able to come back in the moment and answer without having to do research in the meeting.
Absolutely, and we do email some of the subcommittees you could probably talk to. Will tell you that if you email us a question and tell us exactly what it is, we will email you the answer. And it's still, whether the board agrees or disagrees or not, that's fine. It's just we would like to make sure that if you have a question, that we at least are able to provide the answer to you, for you to go forward. And then if you have additional questions, please feel free just, to ask us.
Yeah, and usually they're not dispositive in terms of changing the recommendation, which is why I just put it in the notes section there. But I will say in this particular case, regardless of answering the specific questions or not, there's a number of things that have not been that have not been resolved, whether there's been a full after-action review of this particular instance and the various agencies that are involved. My concern is that you have a situation in which there are multiple entities that are involved in this situation, and you could always be in a position where somebody says, well, I think we were following what we were doing, it's on so-and-so, and then somebody says, actually, it's on them. And so because the recommendation here is exonerated for one of the detectives, I would like further investigation into this, either investigation or process into this, so that we can make a determination of what CPD is going to do. Also, this can tie into ultimately this question that we've had around outcomes, around what CPD does. Now, look, I don't know if there's a way for us to move these cases along to CPD, and then also have ongoing review. I don't know what that process is, but that is a suggestion that I also wanted to put on the table, is that there's a way of saying, we've accepted the IG's recommendation here, but we have further, we want to look into this further. Is there a way that we can do that?
I think, yes, we can always ask the IG to look into certain issues. I think, two, this case itself, I think you should make a motion to send it back, because I think we've heard your reasons for it, which are fine, but I don't think that we can we're not going to fix it unless you send it back via a motion to the IG. And I think those are separate things. I think you can talk about process, and we can ask the IG to look into process. Separate from that, I think this case, it sounds like you want more information or more research, so I would suggest.
I want more information and research. I would love to know more from CPD and the police chief and what their determination is. So I don't want to further delay that happening either. So I don't.
If I may, Chair Burns and Chair Strickland, one, no after action report has been created by CPD for this. However, they are in the process of updating their criminal intelligence SOPs, which will require further training for supervisors of the Ohio State Amber Alert process. That is the only thing that I am aware of that leadership from CPD has passed down as a result of this particular Amber Alert. I would suggest possibly bringing in Deputy Chief Weir. I believe he is responsible for reviewing the criminal intelligence SOPs. He's in the process of reviewing them now. And so it may make sense that once they have their new SOPs, that someone from CPD come and explain them to the board, so you all have an idea of what they are doing in order to address issues like this moving forward. Two, I don't believe the IG has time left to do further investigation on this one. I believe her 90-day time period, and I almost believe there was an extension granted by the FOP already for this case. So I don't know that she has time outside of requesting an additional extension from the FOP, which we want to try not to do, but understanding the impact of this particular case, it may be something that you could consider. The other thing is, and maybe, Counselor, you can look into this. I do know that the board has the ability to bring in folks and have their own hearing.
Yes, we can have it, and that was going to be my next
If you want to do your own
suggestion.
thing, you are not under a timeline to do that. Obviously, the IG will be here to assist, but that may be the most appropriate action in this particular case.
No, so thank you. I agree with that. So I think.
And if I could interject, just to bring it back, IG Hendricks did tell us about 15 minutes ago about those SOPs being updated. So just for sake of no, but seriously, she did say that even with the end result of this report, that she had a conversation with leadership and chain of command, and that they were in the process of updating the Amber Alert process because of this case.
Yes.
So just for purposes of some clarity and making sure that that's noted here.
In regards to the time frame, under City Code, 23503, which is CPRB duties, subsection A5 allows the board to evaluate and identify complaint patterns and make recommendations to reduce complaints, and also to review and make recommendations regarding division of police policies and procedures. So you can make a motion or make a referral to the IG independent of the complaint itself, which is under that strict time parameter.
Yeah.
If you're just asking the IG to review and make recommendations regarding division of police policies and procedures, that is not necessarily under the same time constraint. So,
It did sound like you wanted to hear about some discrepancies in statements that.
Yeah, I mean, I think it would be nice to get an after-action review or something by CPD. I think eventually, I don't, and maybe if the IGs can investigate and figure out why, I think that's helpful. I mean, I think that in this case, I'm happy to accept the IG's recommendation here. Just like I'm happy to accept it in most of the cases, because I think what I want to get to the point of is forwarding these cases along to the police chief and public safety director. And then if there are, like from there, if there are disagreements or there are issues that public safety director says one thing, or the police chief says one thing, and then IG's office says another thing, and there's a disagreement there, we would then, ideally, as a board, whether we set aside one meeting every a quarter or something like that, discuss the divergence that has happened with cases that we've sent over. And so that's kind of my recommendation, because there's nothing that limits us now from, if we say exonerated, there's nothing that limits us then from reviewing this case further or figuring out something further after the disposition ultimately is decided upon from CPD. So I would recommend accepting the IG's recommendations here. That's my motion for 0590. And then thinking about something separately, but we can talk about that later. But that's my recommendation to move forward on this case with accepting the IG's recommendation for of exonerated for case number 0590. That's my motion.
Is there a second? Any other questions or discussions?
was there a second?
I thought, did you not second? Okay. Or is there, okay, thank you, Mac. All
I
right.
hope you guys second.
Any other questions or discussions? All right, all in favor, please raise your hands. Thank you. That concludes the cases from our June, from the July meeting that we didn't get to. We're going to take a 10-minute break. We will come back. I asked the subcommittees to please be prepared to start first with cases that were administratively closed. We'll move on then to cases in which the subcommittees agree with the recommendation, concluding with cases in which the subcommittees disagree. We're adjourned for 10. All right, we are coming back to order. A quick note, I believe it will be quick. 2 meetings ago, we had case 2022-0556. I believe we had an open motion and a second that was then tabled for a later meeting. The case was Board Member McIntosh's subcommittee, and the issue was, for board members who recall, the issue was about a mistaken plate that was removed from a vehicle that matched the description of another vehicle in which CPD officers were pursuing a suspect. I actually need to stop and ask a question. Mr. Tobias, since that case was from 2 months ago, do we have the ability with the board members who are present to actually vote that case forward?
So, I mean, if there's already been discussion on that case that they were not present for, I would say they would need to abstain from that.
Okay.
Yeah.
And that leaves us with how many?
1, 2, 3, 4, 5, 6.
6, so we're good.
You're good. Yep.
Okay, so I will be noting that our 3 newest board members will have to abstain from this because we did have a discussion on the record of this case. I believe our motion, first and second, was to accept the recommendation on case number 2022-0556. All in favor, please raise your hands.
We didn't discuss, I think the reason it was held was not for me to read it. So the issue was that I had an issue with the recommendation of the IG and the subcommittee. Just as a reminder, you all agreed with the subcommittee's recommendation of unfounded. And the concern I had was that it was very specific around how do we ensure this doesn't happen, this type of incident doesn't happen again or doesn't occur because there was a clear mistake here. And I didn't really get an answer on making sure that this doesn't happen.
And just for clarity too, I think we also discussed at that meeting that an officer's mistaken impression about whether a suspect is in a location or in a vehicle in and of itself is not a policy violation. Those were the exigent circumstances surrounding why officers thought that the car was parked in front of the vehicle. And this discussion we did have on the record because we talked at length about this case. I think at the end of the day, I think both your concern is noted, but we can call to vote because the subcommittee agreed with the recommendation. I think you can absolutely disagree with the motion. I don't know that that moves us anywhere unless you have any additional recommendations after reviewing the case. Because I think we held the case for your consideration because it was a different subcommittee that reviewed it. But if there's nothing else that you have questions about.
Yeah, the question is that there were multiple, admittedly here, mistakes that were made on this. One in terms of the VIN number, and then also in terms of the house that they arrived to. There were guns drawn in this situation. So I guess I'm concerned that this situation to me sounds like it could happen again. And so my concern is that, are we not concerned about that? I mean, so are there processes in place so that this does not happen again?
So Kyle, I agree. I don't want it to happen again either. And if I had been in the position of the complainant, maybe I would have complained also. But the issue was the complainant's license plate was stolen, and it matched the vehicle that they saw the suspect near earlier that day. So there was just some confusion with that can happen in any instance. So if we're able to put something in place to resolve this, we can put things in place to resolve all confusion. And I say that to say that sometimes you're going to get these things, and hopefully they turn out well like this one did. I think another thing that maybe we can do better, and when I say we, I'm talking about CPD, and maybe they did. But in a situation like this, maybe we can keep that complaint from happening by simply sincerely apologizing and explaining to that person what happened and why it happened. And if that person doesn't feel any satisfaction, we need to take it a step further. And maybe now the sergeant and lieutenant or commander can go visit that person and reiterate what happened and why it happened, and also, be sincerely apologetic for what happened. And then I think that moves us closer to not getting that complaint than receiving it. But to figure out a way for nothing like that ever to happen again, it's not going to happen, because people make mistakes, and those things are going to happen.
Yeah. No, thank you for that. I just am a little concerned in this situation where something clearly there was mistakes that were made in terms of how this process happened. Somebody files a complaint. They went through this situation. It was an intense situation that they went through. And then our finding is exonerated or unfounded in this instance. And then the further conversation from, I don't know, our response to the complainant in terms of them getting resources or support or further understanding as to why this determination was made, to me, is where I have some concern. So, look, I'm happy to move along with this process, again, just like before, where we move these cases on to the CPD and the Department of Public Safety. But it is concerning that our answer here is kind of like, well, that just kind of just happens.
Yeah, and I certainly don't want that person to feel that way. That's certainly not my intention. In fact, if I could go out and explain it to her, I would.
And I just want to make sure, as our board, are we fine with kind of, that's just, it can happen?
I really like Board Member McIntosh's suggestion, and I don't know if that would be attached to the motion. First, that we accept the finding of the IG. That motion's on the floor. But there could be even a second motion regarding a recommendation of, apology or something like that, at a personal and human level, that there was some attempt to explain and reconcile. So some things can't be addressed by policy, but they can be addressed by a process of reconciliation.
Yeah, and I think if possible, whether we accept the recommendation here and then we make some sort of, whether it's recommendation of policy review or conversation about follow-up, so that we know here in this instance that there's some sort of follow-up that happens as to ensuring that this type of situation doesn't happen, or doing your best. That would be I'm fine with doing that, or some iteration of that.
I would just note for the record, as a person who litigates Fourth Amendment claims, I cannot imagine how often that would require CPD to issue apologies and/or have those moments, because these types of things happen all the time in actual cases that are filed. So I can't even imagine how often they're happening in things like this that don't result in a case being filed against a citizen. And so I would hesitate to think that we could kind of demand a policy of that volume, because it seems like it's a Fourth Amendment search and seizure issue, looking into someone's private, property, home, those sorts of things. And I imagine the volume would be astronomical to imagine, because mistakes, that's part of why exigent circumstance case law exists, because those mistakes are sometimes what allows officers to engage in those searches in the first place. And then they engage and then find out, oh, it was wrong. Like, we were wrong. And this isn't the first time we've actually had a handful of cases that have come before our board, some in front of my own subcommittee, where a neighbor called because they saw a homeowner who had locked himself out of his home breaking into his own home to get in. And so then a neighbor calls, doesn't realize it's the homeowner. Officers call, they have guns raised at him, and it was a mistake. It turned out that was the homeowner. And so I don't know that, I don't think we are making it sound as flippant as it's sounding, like, oh, it's just fine. I don't think it's that. I think it is, yeah, it is terrifying when that happens. None of us want those things to happen. At the same time, if law enforcement officers, even if mistaken, pursue and are wrong when they open a door, when they think that they're impounding the right car, like in and of itself, that mistake is not something that I think we can policy away.
And the additional thing that I'd add is it's a good faith belief, good faith mistake, and that's why it lends itself to exoneration. So if they were mistaken and knew they were mistaken, found out they were mistaken, and then continued with the behavior, that might be a different analysis and would probably lend itself more to your concerns. And then the other thing I'd say, just in terms of process, your point's well taken. Just I'm making a distinction between having full discourse and discussion about the complaint and then moving to a vote on that versus your concerns about more policy and practice. And I think you said maybe scheduling a separate meeting to discuss those issues or carving out a special place on each agenda to talk about policy issues.
Okay.
Might be a way to kind of get the complaints moving forward and then setting aside additional time or extra time or separate time to discuss policy and pattern and practice.
Yeah, that's helpful for me. I mean, I just want to get to the point where, we can move these cases along, but then it doesn't just go into black box, which is kind of where it seems right now. Like we don't know where any of our recommendations are going. And so if we then had the opportunity to follow up after the fact, following up with complainants, using our ability to communicate with the public about what is going on, that follow-up piece is something that is missing from all of these cases. And so something that I want to consider, whether we carve it out in our meetings or a separate meeting, but I'm happy to move forward with this recommendation on this case. No further points on my end.
All right, we've got a motion and a second on the floor in case number 2022-0556. All in favor of accepting the recommendation, please raise your hands. Any opposed? And we've noted our 3 abstentions.
Chair, I would like to pick up on Member McIntosh's recommendation. I have no idea what the volume would be of apologies, but, even if it were in the instances where a complaint was filed, it doesn't seem to be that many that we're having complaints filed, a mistake made. We've had a few, but in the course of the several hundred cases we've gone through, there's only been a handful that I can recall. And, we're here to attempt to part of our role as the Civilian Review Board is to attempt to bridge this lack of trust, the alienation between the public and the police. And I would support, I think that's a wonderful idea, frankly, to have police officers reach out to complainants where there hasn't been a breach of policy, but there's been a violation, and so I would support a recommendation that we have, a personal connection. So there you go.
I'm going to say that that's probably outside the scope of your duties and responsibilities.
Well, I'm recommending a change in policy, so that we're making a recommendation to the police chief that there be a policy that in the cases where there are complaints, that there be, a personal outreach to civilians in the same way that we recommended a change of policy regarding interpreters or anything else.
And I'd probably take some time after the meeting to discuss it with Ms. Ross in terms of like the bargaining agreement and FOP and whether that's problematic or not.
Okay.
And is there a way for us to, as a civilian police review board, do that? I mean, or charge or ask the IG's office to do that sort of follow-up engagement? Because I mean, I agree that generally there should be some sort of, there might not be a violation of policy here in a particular instance, but clearly there's a situation that, you felt you were wronged, and in this case, there was mistakes that happened. So I don't know if that's something we do, CPD does, or public safety, the city does. I'm interested in that, if that's a possibility.
I'm going to just caution about some sort of policy related to offering apologies. Just, again, tread lightly, and I would want to consult with Ms. Ross about that. Again, it may be outside the scope of the IG's duties and responsibilities as well, in terms of if you make some recommendation directing them or asking them to consider doing that. Want to confer further with Ms. Ross.
Is there a practice?
Well, let me just say this too. What I was trying to get to is that those officers, while there on scene, after figuring it out, they can do the apology, not necessarily waiting for the sergeant or the lieutenant or commander to come out. Those officers, once they find out that that's a mistake, then they themselves can take the time, just like they were taking the time to pursue or effect an arrest on a felon. They took that time. So maybe they can take 5 or 10 minutes to explain and teach and make her aware of what they did and why they did it. And maybe that would result in the person not complaining, which then takes away from the IG from investigating it in the first place and us coming to the conclusion of exoneration. So maybe we can stop it here before it gets here. That's what I'm saying. I certainly would hope that if I were to have done that or did that, that I would at least pull that person aside and say, hey, I'm truly sorry. This is what happened. We got a little confused with the vehicle and the license plate, and show some sincerity and empathy, and that person probably would de-escalate themselves and not complain. And that's my goal. I'd rather not have the complaint in the beginning, if we can stop that. So I'm not trying to create any more work for CPD, but sometimes a simple "I'm sorry" and it's sincere will get us there.
I mean, you made that. I mean.
Is it possible to table that motion, allow Tobias and I to confer?
Yep.
And then put it on the agenda for the next meeting, and then we will at
Absolutely.
least have come up with an answer about what you can do and parameters for moving forward with the recommendation.
Yes, thank you. All right, moving on to July cases. First, any cases that were administrative closures or withdrawals? Do any of the subcommittees have any that fit that category? None? Okay. Moving on to cases in which subcommittees agreed. Turning first to Board Member Nathan, and we will then move to Board Member Strickland and Board Member McIntosh.
Yes. Do you want me to, okay, so this is case number 380. Complaint alleges that an officer went through a red light, causing pedestrians to have to halt as they cross the street. In this case, there was no body-worn camera footage, but the officers in the case denied the claim. The officer claimed that the light was not red. They were quite specific. The officer had quite specific recollection of this situation. Another witness on the scene also corroborated the officer's story, so the Inspector General concluded that the complaint was unfounded. I move to agree with the Inspector General's finding of unfounded regarding case number 380.
Second.
Any questions? All in favor? Oh, I'll wait to call the vote till you get through your cases. Apologies.
Okay. This is case number 392. This incident arose as a result of neighbors contacting the police because the complainant's child was screaming for 45 minutes and there was no one offering any help or care for the child. The officers came to the complainant's house. They knocked on the door loudly and repeatedly with no response. They could hear the child screaming from outside. The door was unlocked. They went in. They found the complainant passed out on the sofa. They attempted to awaken her. The officer got the child and noticed weed in the house and also a syringe. They shined a flashlight on the complainant. The complainant alleged that the light was shined on her private parts. That was not supported by body-worn camera. The light, according to the video, the light was shined on the child. The Inspector General concluded that the complainant's allegations were unfounded, and in case number 392, we move to accept the Inspector General's conclusion of unfounded.
Any questions?
Case number 426, the complainant alleged that the officer didn't properly investigate the burglary of her rental car. In this instance, the complainant alleged that the car had blood on the seat and the officer didn't do a DNA test on it. The officer told the complainant that a technician would not come to the scene for a DNA test since this was a misdemeanor and not a felony. CPD policy does not require a DNA test in the case of a misdemeanor. The Inspector General concluded that the complaint was unfounded. We agree, so I move in case number 426 to accept the Inspector General's conclusion of unfounded.
Any questions?
Case number 430, the allegation in this case arose out of a dispute between neighbors. A CPD officer who lives in the apartment complex where the dispute arose and was a special duty officer there handled the complaint. Complainant alleged misconduct on several grounds. Number one, that the officer failed to make a report. The officer, in fact, did file a report both to the with the apartment complex and also with CPD. So the Inspector General concluded that regarding allegation number one, this was unfounded. Second, that the second allegation was that the officer failed to call backup. The officer assessed that he didn't need backup, and so the Inspector General concluded with respect to the second allegation that it was unfounded. And third, that the officer spoke down to the complainants. The officer disputes this. There was no other corroborating evidence. And so the conclusion by the Inspector General was also unfounded. We support, I move in case number 430 to agree with the Inspector General's finding of unfounded with respect to all three allegations.
Any questions?
This is case number 436 is a bit complicated, but the complaint arose from a traffic accident involving several cars. The complainant alleged the excessive use of force by an officer when she was pulled from her vehicle. She alleged that she was pulled from her vehicle by her neck and shoulder and had her arms forced behind her, even though she informed the officer that she was hurt. The officer stated that there was a bullet hole in the complainant's car window which he assessed was shot from the inside, and the complainant was moving around in the car, which made him uncomfortable. He asked the complainant to step out of the vehicle, but the complainant didn't comply. He ordered her out several times, told her if she didn't get out, he would pull her out. She didn't get out of the vehicle. He claimed that he pulled her from the vehicle by the arm and not the neck, and handcuffed her. No weapon was found. There was no finding that she was not, there was no evidence that she was yanked by her neck and not by her arm, according to the body-worn camera. The officer also had reason to believe that she was not hurt because she had been out of the car before and was moving around, and then got back in the car and was moving around in the car looking for her phone. The officer didn't know that. He thought she might be looking for a gun because of the gunshot. And so regarding the allegation that, let me just get all of these. There was no evidence to substantiate the complainant's allegation that she was pulled by the vehicle after she reported she was hurt. And so it's recommended that the allegation be closed with a finding of unfounded. And also, there was no evidence to substantiate the complainant's allegation that they used excessive force because she was not snatched by the neck and shoulder, but rather by the arm. And so in case number 436, we move to accept the Inspector General's findings of unfounded with respect to both allegations.
Any questions?
So in this case, it says that they don't find excessive force because they weren't pulled by the neck, but were pulled by the arm. I mean, is there?
Well, it wasn't that she was pulled.
She wasn't pulled.
She was just led out of the car by her arm. She wasn't like yanked.
It was like they had, like he reached out, basically touched her arm, and then she got out the car. So he didn't pull her out. She got out on her own will.
Okay. And the question around the guns drawn piece was because of she was looking for her phone, or?
No, there
were no
there were
guns
no
drawn.
guns drawn.
Okay.
No, there were no guns drawn, but with respect to the reason that he was ordering her out of the car and was concerned was there was a bullet hole in one of the windows that one of the officers concluded, based upon his knowledge of ballistics or something, that the bullet came from inside the car out rather than outside of the car in. So they were concerned that there was a gun. She got out of the car, then went back in the car and was reaching around on the floor in the back, and that further alarmed them that there was the possibility that she had a gun. That's why they were ordering her out, and that's why they handcuffed her.
And did we determine the gun shot in the?
There was
window?
no ballistics that I'm aware of.
Okay.
Any other questions? Okay.
This is case number 450. This complaint arose, the complainant suffers from various mental health issues, including paranoia, and he said to the officer that he believed that his neighbor was entering his apartment through the glass door. He alleged that when he made the complaint, the officer would not help him and talked badly to him. The conclusion from the body-worn camera was that the officer was very courteous and helpful regarding his allegations, and that the officer did keep telling him that what he was seeing wasn't real, and that he shouldn't shoot anyone. in response to what he was perceiving. The officer appeared to act completely appropriately, given the psychological state of the complainant, and so the Inspector General concluded with respect to the allegation that the officer wouldn't help him and that he talked to the complainant and the neighbor badly, that both allegations were unfounded. In case number 450, we move to accept the Inspector General's findings of unfounded.
Any questions?
Was there a referral to another agency or services to support
Did
the
not
individual?
find it in this case, I don't think, that there was a referral to, there were multiple complaints from this complainant over the course of this time period, but I'm not aware of a referral to, social services or
Yeah.
something like that.
Is there a policy that there, in a situation like this, there should be a referral or somebody gets contacted, or I don't know. I'm not familiar if there's a particular policy or practice, what somebody does in that situation.
So in this case, hopefully I'm answering your question. The complainant's allegations was against the officer. So there are times that my investigators, we have information from other agencies. We sometimes diplomatically, if we feel that a person is receptive, we might give them a number. But I can tell you just from talking to some of my investigators, people are not receptive when we try to give them a number for another agency sometimes, unless they are asking us for help, just because we read something and we've identified that maybe that person might need to talk to someone that could probably give them guidance. They're not very receptive to that.
That's helpful. I think generally part of that is similarly to the previous, if we think about a follow-up, some sort of follow-up, a decision has been made, and then we think about how we communicate about other resources being available
Yes.
if folks need something. Thanks.
And then finally, case number 462, this complaint arose from an incident in which the complainant was alleged to have a knife by a man who was living with him. When the officers arrived on the scene, the complainant was outside in his driveway loading his van with stuff. The complainant began moving towards the officers, shouting obscenities at them. They tried to handcuff him, and he resisted. One officer did take him to the ground. He alleged that they used excessive force and were retaliating because of his offensive language, and that the officer was personally offended because he was using offensive language. The Inspector General concluded that the officer that took him to the ground was acting within the use of force guidelines of CPD, and therefore concluded that the complaint was unfounded. We agreed. He kept resisting. They were concerned that he had a knife. And so in case number 462, I moved to support the conclusion of unfounded with respect to excessive use of force.
Any questions?
I might have missed this. Did this complainant have a knife?
That does not appear in the, I don't, there was nothing in this, in these findings that he, it didn't confirm that he had a knife.
Yeah.
he was moving towards them, it says, in an aggressive manner as if to fight, and was shouting obscenities as he was moving towards them. And so they attempted to handcuff him, and that's when he began resisting. And
Yeah, I mean, the concern I have is the statement made that there was a concern that he had a knife, and so it would be helpful to just get follow-up whether or not he had a knife, whether or not that ultimately changes the outcome.
yeah, I don't think that would change the outcome.
And so is there a circumstance by which it would? I'm just trying to get a sense of why that was included.
So the use of force was predicated on his resistance, not so much the knife.
But you could imagine a scenario in which if somebody says that somebody had a knife, then that would, my understanding, I don't know, that would impact how that use of force scenario is determined, right? If somebody indeed has a knife versus if they don't. I'm just trying to get some clarity on that. I don't know.
Well, it might. I would say it probably would. The report initially came in that he did have a knife, so officers were acting with precaution. And the fact that he was demonstrating volatile behavior towards the officers and yelling explicatives, and then when they did try to restrain him, then he was being resistant. All of those factors then followed into how the officers conducted their use of force.
Any additional questions on that case?
I mean, okay. I mean, I'm confused. So they started approaching him because he was coming after them.
He was approaching
Yeah.
them, so they
But
came.
the call.
The call came because because his roommate said that he had a knife and was threatening. They then showed up at the apartment complex. This guy was loading stuff into his van out in the driveway. And when the officers showed up, he turned and began screaming obscenities towards them and approached them in a manner that they felt was volatile and threatening. They attempted to handcuff him. He resisted and fought with them while he was screaming at them, and then he was taken to the ground. That was the...
Yeah, I do think it would be important to know whether or not this individual had a knife. I don't know why that was not included, or is it just kind of like one of those things where it doesn't?
Well, I think this is one of those examples where whether a knife was found or not is not relevant. It's what was in the mind of the officer at the time what was the nature of the call when they got there, what was in the mind of the officer in terms of what actions they were taking, why they were taking them. Whether there was a knife discovered or not is really not relevant to what their use of force was in terms of the resisting allegation, the excessive use of force allegation. It's what we were talking about earlier. If they were mistaken, let's say they were mistaken and there was no knife, if they were operating under a good faith belief in the actions they took and those actions were within policy, then that lends itself to the exoneration.
So what was he being arrested for?
I didn't see the report.
What was the arrest for? Disorderly or resist, I mean,
I don't know that he was actually,
what was he
they were trying to detain him because of how he was
Because he-
behaving
yeah.
towards them.
Okay.
Responding to a call because his roommate felt threatened, because his roommate says he's got a knife and he's threatening me. So that's why they came.
Yeah,
And
so
then when
they-
he was
they
combative
viewed it
with
as a
them,
detention.
They tried to
Yeah.
detain him.
They tried to detain
And when
him.
they initially said, as he was loading stuff on the van, they asked him to come, he was not complying
okay. Did they handcuff him?
Eventually,
eventually.
Yep.
yeah. They tried to handcuff him, and he kept fighting with them.
He was pulling away.
I mean,
So then he was being arrested. If he was being handcuffed?
No, you can detain somebody
Yes.
by handcuffing.
Okay.
them.
Without
And so-
arrest.
So he was being detained because of his irrational behavior, because
Or aggressive.
aggressive
Threatening.
behavior.
Towards the officers,
Okay.
I mean, to me,
And
it's like.
because there was a complaint that.
that he had a knife.
A knife and was threatening.
So I get that part, but I'm a little confused by the fact that there's a complaint that he has a knife. The call was because he had a knife. It doesn't even indicate whether or not he has a knife. I understand the fact that there could have been a good faith belief that he had the knife, but it seems like whether or not somebody's aggressive or has been is believed to be aggressive, if they're armed versus if they are not armed, that does seem to be somewhat addresses why somebody's subjective belief in that situation. There they come in, they've got a call that somebody has a knife. That is part of this. In this instance, he may or may not have had a knife. He was shouting obscenities back to the officers. I don't know why he was shouting obscenities to the officers. Is it because I don't know why that happened either. So that's just my concern, is that we just don't even know.
Again, the issue of whether he had a knife wasn't relevant to whether their behavior was within use of force guidelines. In this instance.
But in other instances, I just want to so I'm clear, in other instances, it is relevant. Is that correct?
Well, yeah, I mean, if somebody's not moving in an aggressive manner towards them and shouting obscenities, and they don't have a good faith belief that they have a weapon, they have no right to just simply, I mean,
Well, I was going to say, I think we should look at this situation in isolation and not try to merge it up with other situations. So I was just focusing on this one. And in this situation, the knife really wasn't relevant, like I said previously. It was his disposition and demeanor towards the officer when they arrived on the scene.
I'm going to echo that. These are all case-by-case analysis based on unique and specific facts and circumstances. So, and then when the officers are responding, they have a duty and an obligation to make sure there's safety for everybody involved and to investigate. And the situation could have gone differently had the person that they encountered been calm and cooperative. But once they are trying to interact with the person to investigate, if that person is not calm and cooperative and is aggressive and violent and volatile, then that dictates what amount of force they can or cannot use, and it's just a fluid situation from there.
So, what's next? I have motions on all of these cases. That's the end of the
Yep.
cases.
Was there any other questions about that case? Okay. We've got open motions and seconds on case numbers 2023-0380, 0392, 0426, 0430, 0436, 0450, and 0462, all of which the subcommittees have recommended agreeing with and forwarding on the recommendations by the IG as written. All in favor, please raise your hands. Thank you. Motion's carry. Team two?
So we are going to move this over to Board Member McIntosh. I will just want to highlight on this review of case number 0330 that was said to be held over. That's actually for this meeting, the August meeting. Case number 330 is included in that number here. For Investigation Review Committee number 2, Kyle Strickland, you have 29-3, 29-5, 326, and then 330. So I don't know where the.
I think it was just a typo, but it's a case for today, though. So that was really my only thing was clarifying that case was happening today.
We have not reviewed these sets of cases,
Okay.
And so we'll review that for the next meeting. So I'm going to hand it over to Board Member McIntosh.
All right, I'll start with case number 23-0124. The complainant reported 4 allegations to the IG. Allegation number 1, officers used excessive force when arresting the complainant. Allegation number 2, officers did not check to see if the father had warrants after the complainant told officers that the father had warrants for his arrest. Allegation 3, the officers did not check to see if the father had a valid driver's license. The IG had 2 allegations, that one officer turned off her BWC when she began to talk with the father for a second time. And allegation number 2, the other officer used rude language when telling the complainant to shut up. Basically what happened, and this is after a review of the body-worn camera footage, statements from the complainant and officers, policies, procedures. What it revealed was that this complainant was arrested for an assault. When officers went to handcuff her, she resisted a little, but they finally got her cuffed. There was no excessive force in cuffing her. Once inside the cruiser, she then started yelling, and she had previously been yelling and cursing at the officers when they got there. She started yelling at the officers and asking them to contact the father of her children because she was being arrested. And instead of them going probably to Children's Services, he could take custody of them. Officers did contact the father. He did come. Once he came, she then flipped and started telling the officers that he had warrants, that he didn't have a valid driver's license. Now, normally on disturbances, officers do check and run 50s. But in this case, this person was intoxicated. She wasn't believable. She wasn't credible. So officers did not check to see if she had warrants. I know the ID did later check to see if he had warrants, and he did not. And as far as the IG's allegation, the one officer, the female officer, did turn off her BWC when she spoke to the father who arrived on scene. And in fact, the other officer did tell the complainant to shut up. She was yelling and cursing. He did tell her to shut up. So I motion, well, the IG's, let me tell you what her findings. Allegation 1 was unfounded, and that was the excessive use of force. Allegation number 2, officers did not check to see if the father had warrants, exonerated. Allegation number 3, officers did not check to see if the father had a valid driver's license, exonerated. And allegation 1 and 2 from the IG were both sustained. So I move that we agree with the IG's findings and all 5 of those allegations in case number 23-00124.
Any questions on that case?
Case number 23-0127. In this one, the complainant alleges that the officer failed to complete a police report for her telephone harassment complaint. The investigation found that the officer did not complete a report. She called because her child's father was harassing her. The officer responded. He took down all of her information, gave her a report number, told her that he would complete a report. He left there, went on different runs, and forgot to take the report. So it was found that he did not take the report, and he admitted so. He did finally take the report. The complainant reported this January 24th of 23. The report was finally entered into the system on March 30th of 23. So, the IG recommends that this allegation be closed with a finding of sustained. And I motion that we agree with the IG's finding of sustained in case number 23-0127.
Second.
Any questions?
I just have one question
Yes,
about
ma'am.
that one. When the officer did complete the report, did he complete it after he had spoke with the IG, or was it some other time?
Let's see here.
I'm just trying to get a general idea of how far from the incident to when the report actually happened that he completed it.
Yeah, so the date of the incident was January 24th. The date of the complaint was February 10th. Let's see. Yeah, March 30th was when the report was entered in the system, but I don't know the date that they actually interviewed him.
Okay, that's all I wanted to know.
Yeah.
March the 31st is when she interviewed the officer.
Oh, okay. Yeah. Thank you. Case number 23-0129. The complainant alleged that the officer misused the OLEG system by creating a Halloween mask from a mugshot. Allegation number 2 was that the officer enhanced her breast and buttocks areas on the costumes in a way that was inappropriate for the workplace. So this involved a CPD officer and a Franklin County officer. And basically, they worked for the Human Trafficking Task Force. They were looking for an individual and his co-defendant, and they printed off their mugshots from the Ohio Law Enforcement Gateway system. And they did that so that they could go to different places where these people frequented to see if they could arrest the person. The person finally was arrested. So initially, them printing off the mugshots was work-related. However, the Halloween party comes, and they decided to use the mugshots as a Halloween mask. And that was a no-no. That was against policy and procedure. So the IG sustained that. However, as far as enhancing their breast and buttocks, there was nothing to show that they did that. So, that being said, I motion that we agree with the IG's finding of sustained for allegation 1 and unfounded for allegation number 2.
Any questions on that case?
What is the recommendation from the IG or from the board regarding the response to this behavior?
Say that again.
I just wonder what the recommendation was. We sustained the complaint with respect to the first allegation. I just wonder what the recommendation was. It discipline, was training? What was the recommendation?
So the IG is not going to give specific recommendation with regard to discipline. It's just going to be a finding of sustained. It's going to be up to CPD to determine what type of discipline. And if I am correct, I believe certain discipline has already started for this particular officer with regard to this incident from CPD. I'm not sure what it is, but.
So looking forward to knowing what that is. I mean, I don't know, the IG may not be able to make that recommendation. I think we as a board can make the recommendation nonetheless for recommending discipline. I know we have to do something separately in terms of the emotions,
Well,
but
I don't know that we do.
It's in
Board
there.
Member McIntosh, could you read the conclusion on the report,
Okay.
please?
The recommendation part.
All right. The Columbus DIG reviewed the evidence provided by CPD and Grove City Police Department and the statements of the focus officer and a witness officer and concluded the following. The officer was found to have misused Oleg in creating this costume and was found to be outside of CPD policy. Therefore, it's recommended that this allegation be sustained. Allegation number 2, the officer's costume did not appear to have any enhancements applied that would be inappropriate to the workplace, and no evidence was found to suggest that it had been. The officer and the sergeant were unaware of anything that may have been construed as an enhancement, inappropriate to the workplace either. Therefore, it is recommended that this allegation be unfounded.
I think
Um,
recommendation.
Board Member McIntosh,
Okay.
can you read
It's the last page.
item number 7, the recommendation, please?
Yep. Based on my review of the investigation and supporting documents, I concur with the investigations and aforementioned recommendations. Also, it is recommended that this investigation report be forwarded to the Chief of Police, Columbus Division of Police for review and consideration of disciplinary action in accordance. Okay. Yeah.
yeah, I mean,
Procedures
Yeah.
and a collective bargaining agreement.
Yeah. Okay. Consideration of disciplinary action in accordance with CPD policies and procedures and the collective bargaining agreement between the City of Columbus and the Fraternal Order of Police, Capital City
Yeah,
Lodge
we got-
number 9.
so.
How's that?
So, yeah, I mean, I think that's the language, though, which is consideration. Did we determine whether or not, as a board, we can make recommendation for discipline versus
I think
recommend
that's,
to consider or
I think
to
that's
think
what
about
we
it?
can do.
So we can make a recommendation
No,
for
I think,
disciplinary.
I think the language that is in there is what we can do. Because at the end of the day,
Recommendations on discipline. So when you adopt the finding of the IG, who in the report has recommended discipline, you're basically saying we recommend discipline as well, and that's getting sent on, but not specific recommendations.
So if the idea then is that the decision is made, if there is not, say, if there's not discipline, could we make, with a follow-up, make a recommendation for the consideration of discipline?
If the IG's report doesn't contain it?
If CPD does not issue discipline in a particular instance.
No, the recommendation on discipline,
But I thought.
the recommendation on discipline would come now when you're reviewing the complaint. And if for some reason the IG, you didn't agree with the IG and you wanted to recommend discipline, you could vote on that here and send it along, but nothing after the fact.
But on this particular case, didn't you, Attorney Ross, just say that you think disciplinary action has started?
Yes, already internally with CPD. However, because there was a separate citizen complaint made, there may have to be some sort of convergence between what CPD has already started to do and what they can do, given the parameters of the FOP and the constraints of the FOP contract. So
Yeah.
CPD will determine whether or not their misconduct is going to be sustained, and then they have to look to the contract to make a determination about what type of discipline has to be issued pursuant to that misconduct.
Yeah.
So if you want to, I think pursuant to charter, and tell me if I'm wrong, Counselor Tobias, pursuant to the charter, if you'd like to suggest a specific type of discipline, you can. However, I would suggest you all be very much more educated on what is required from the FOP contract before doing that. And it is a lot. It is very intricate, which is why the IG has made a policy decision not to do that and just recommend that discipline be wrought within the guidelines and parameters of CPD past practices as well as FOP.
Yeah, and that's help, and I think, the consideration, the recommending the consideration of discipline, I think makes a lot of sense. My concern is when it gets to this instance, or to that decision, and either discipline is issued or not, I'm not sure what keeps our review board from saying that doesn't seem like, they should have issued discipline in that case, like after the fact.
You just don't have the authority to do that,
Yeah.
In what sense?
in every sense. That's just not within the charter or the city code, within your authority to, I mean, you can issue some sort of statement if you want, saying you disagree with the police's decision. That's up to, you certainly can do that, but they're following the bargaining documents in terms of their institution of the investigation and progressive discipline. Yeah, that, I mean, this board has authority, but it's limited. It's a recommendation, it's an advisory board, and ultimately CPD, following the contract, is going to make the final decision.
The language, I understand not being very specific in terms of what our discipline is, so that this is ultimately what CPD can decide, but the language around for the consideration of discipline is not recommending discipline. Like, as a board, we are not recommending discipline. We are recommending they consider discipline. That's a different recommendation.
If you want to use language that just says we recommend discipline, you can do that.
Okay.
For sure.
And to add to Ms. Ross's comment, in the charter under Section 216, Powers and Duties, the language is a little bit different. It says, where warranted by the facts, may make recommendations pertaining to discipline, which is a little bit different than what's in the code, but I still would say it's the same theory. You can make recommendations pertaining to discipline, meaning you can recommend discipline, but not specific discipline.
Okay. That would be my recommendation for discipline, not just the consideration of discipline.
Are you asking to amend Board Member McIntosh's motion?
Yes.
Okay.
If you're open to.
Do we have a second on the amendment? Okay. Board Member McIntosh, I think you'll have time for one more case.
Yeah,
Yep.
Case number 2023-0138. The allegation in this case is the complainant alleges that the officer continued to drive past the school bus when stop sign was extended and flashing. On February 14th of 2023, the complainant filed a complaint with the DIG. Complainant indicated that the cruiser passed the school bus, but the paddy wagon stayed behind. The bus sign was extended and flashing. The DIG obtained unit history, BWC footage for the officer at issue, as to time frame provided by the complainant. The BWC shows a school bus on the opposite side of the street, briefly stopping. The DIG also reviewed the cruiser video system with no footage as to the issue at hand. Then they gathered BWC for the other officer, that the cruiser number was mentioned by the complainant. After the review of this officer's BWC, one could see that cruiser 88 was assisting officer at issue, but the school bus could be seen in motion and not stopped. Another video began recording for approximately the same time as the possible incident, and there was no school bus in sight. So the DIG reviewed all possible footage from all possible cruisers. Thus, the DIG found no evidence to support this allegation. The recommendation is closing with a finding of unfounded. We concurred with the DIG. Our committee, so this committee moves to accept the findings of the DIG as to case number 2023-0138.
Do we have a second?
Second.
Any questions on that? Okay, so we have open motions and seconds on case numbers 2023-0124, -0127, -0129, -0138. All have been moved and seconded. All in favor of passing them as they were motioned or amended, please raise your hands. Thank you. Those motions carry, and we'll consider the remaining cases for Team 3 at our next meeting. A couple quick notes. September 5th, we do have confirmation that we will have Public Safety Director Bashadi here for our September 5th meeting, as well as Commander Lip, who will give us an overview of BWC policy. So that is, if you remember, one of the things we asked for additional information on was body-worn cameras for officers who currently are not required to use them. So they are coming in response to that. And then I wanted to leave space. I believe Board Member Younger may have a question for the IG and/or a recommendation for the filing of a complaint on behalf of the board.
Chairperson Brooks, I wonder if we could, if we might circulate a request for questions for the safety director, so that it isn't just a kind of spontaneous thing, but rather perhaps over the next 3 or 4 weeks, a little a letter be issued to the board asking for questions. Maybe we could have a bit of back and forth so that we could be prepared for that time, since we've been asking for the safety director to show up. I think there was, a few things that we definitely want to prioritize. I'd love for us to have a bit of an agenda so that we ask the important things, and some of the other things we might say maybe another time, but yeah.
I think if board members have questions, I would submit them to myself and Stephanie probably within the next, 2 weeks?
That'd be great.
Because remember, there is a holiday weekend also immediately before that, so I would hate to get things to Ms. Bishotti too late.
And can we get a date certain on a response from, an update from the reports that the CPD has completed? I mean, I think it's important for us to get a date. And I think we've been talking about it for a while, that we will be hearing some outcome from the report, but I do want to put it on the record that we've asked, and I would love an actual date certain to get that information. Can we get that?
We are in the process of working on, it's a lot of reports that we have gotten back. We're trying to put all of that stuff into a database so that we can do a report. Our goal was to try to present something to the board on the 5th, but we could give you whatever we have thus far. But what we're trying to do is, as the reports are coming back, we're trying to enter that information again to be able to provide it. So I should have something, whether we do a presentation or not. I know there's a lot going on the 5th, so I would venture to say I would rather provide a written report,
Yeah, no,
to
Yeah,
the board, so that you'll be able to see. In the report, basically, what we're looking at is to be able to provide 2 things that the board has asked. One, Pastor Nathan asked for a finding of reports in which the board concurred and didn't concur, and then how CPD also, whether they concur or not concur. And that's what we're trying to put together, all of those findings.
That's excellent. And then it would be helpful just for our records too, and it probably is already included in the report, just in terms of the time in which you've all, made a request, and then CPD goes through its process, that timeline, and then gets you the information, right? So that, because we know that, you're trying to compile these reports, but there's other entities that you've got to work to navigate around, right? So it's not all on your office as to why we haven't gotten these reports back. Is that correct? I'm assuming that's correct.
Well, there's a process that the chain of command goes through. What I will say, what we'll probably be able to provide to the board is the report we're looking at is the date that we closed it. We're using the date that the chain of command has closed it and given it to us. Now, I think the board will be able to see, when you look at the spreadsheet, you'll be able to see the date that the board approved it. So what I can say, the date that the board approves it, usually within a week, we're sending that information over to CPD. Now, we're not going to have dates of how CPD's chain of command, but what I will say is that CPD provides documentation for us. So if there's something specific that you want on a report and you want us to email you that documentation, we can do that. I can't tell you how long that's going to take, because be aware, there's tons of reports.
Of course, yeah.
But what we are putting together is the date that the report was closed and the date that we got it back from CPD. Now, one thing I will say that I did notice when we were putting this together, I'll be real quick, a lot of the sustained, we don't see a lot of that back, but that's probably because they still have another step that they got to go through. But some of it does say they concur. But as far as the disciplinary action, we don't have any of that data.
Okay, that's helpful to know. Thank you so much.
All right, turning it over now specifically to Board Member Younger so that she can present a case that she would like the board to consider.
I did speak
For
with the
complaint.
IG regarding a shooting, the death of Antoine Lindsay, and the IG indicated that she doesn't think that a complaint was filed, so at this point, I'd like to, I believe it happened, I saw the article in the paper on July the 14th, so it happened sometime the beginning part of July, and if there is no complaint filed, I'd like to, it's probably at this time with with BCI, but I'd like to go ahead and file a complaint so that the 90-day period doesn't expire.
And was that a shooting death?
It was a shooting
member, okay.
death, I believe. There were several agencies involved. I don't remember all the facts right this minute.
Okay. Can you put it in a form of a motion?
Yes, I would move that, I can't remember what I need to say. I would move. I would like to move to initiate a complaint as to the shooting death of Antoine Lindsay.
You need an investigation?
Investigation. If one has not already begun after the completion of the investigation. Well, there's probably investigation by by Lund BCI at this point. After the investigation by BCI is completed, then the Inspector General would begin theirs.
Yeah, then I don't know if it's possible to make like board-initiated policies, because we've made these separate instances, but like in these instances, as a board, to initiate policies or to initiate an investigation or a practice that the IG's office would open an investigation.
We already have a policy that allows that.
Okay, so is this not?
Yeah, no, she's making the
she's
motion,
making the
so
motion.
someone needs to second it, and then we can vote.
I second
And
it.
then one, okay, we've got a second. All in favor of asking the IG to open up an investigation or / initiate a complaint in the shooting death of Antoine Lindsay, please raise your hands. All right, motion carries. Thank you. I would now also entertain a motion
So
to adjourn this
moved.
meeting. All right, all in favor of adjourning, please raise your hands. Great.